All present in the Red Bull courtroom. Session W2 of the Walker-Moot Supreme Court is now in session. It is with great honor and privilege that I present Justice Elena Mamay of Gowling, Justice Christine Kusi of BLG, Justice Melanie Sutton of Nelligan O'Brien Payne, and Justice Colleen Byrne of Byrne Tucker Lashine presiding. Justices of the panel, I present to you, speaking on behalf of the appellant, Ms. Armstrong, in today's matter before the court, Bianca Hosseini and Maya Cheaib, and speaking on behalf of the respondent, Dr. Ward, Holly Pellatt, and Veronica Cesario. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and respondent's counsel will have 30 minutes each, 15 minutes per council member. This includes presenting their arguments as well as answering questions from the bench. The appellants will present their arguments first, followed by the respondents. A 3-minute optional rebuttal will follow by the appellant. I will signal to the court when there's 5 minutes left per speaker. The court now invites counsel for the appellant to begin.
Good morning, justices. My name is Bianca Hosseini, and my co-counsel and I represent the appellant, Karen Armstrong. So the case before us today concerns a laparoscopic colectomy that was performed by Dr. Ward on Ms. Armstrong. The reason for the surgery was to remove her colon. During the surgical process, the appellant sustained injuries, and more specifically, her ureter was injured. This injury in turn resulted in Ms. Armstrong also having to get her kidney removed. At the trial level, Justice Mulligan concluded that Dr. Ward produced the injury to Ms. Armstrong's ureter, and by doing this, breached the standard of care that was expected of him as a reasonable and prudent surgeon. The decision was reversed at the Ontario Court of Appeal. The majority held that the trial judge's analysis was incorrect in multiple ways, all of which I will subsequently discuss. There are 4 main issues that we will be addressing today, and these issues fall under 2 subsequent categories. The first one is standard of care, and the second one is standard of review. In regards to standard of care, first, we need to determine what the requisite standard of care for medical negligence in Canada is, as well as how this can be applied to the circumstances of our particular case. Second, we need to identify whether causation can or ought ever to be used as circumstantial evidence in order to inform the standard of care in medical negligence cases in Canada. Third, we need to examine the evidentiary burden on the plaintiff and determine whether the plaintiff has a duty to rule out non-negligent causes. And ultimately, fourth, with regards to the standard of review, we need to determine whether the majority at the Ontario Court of Appeal erred in applying a correctness standard of review. Today, the appellant submits 4 main arguments. First, the trial judge did not make an error in his understanding of the standard of care as it applies to the particular circumstances of this case. The judge concluded that a reasonably prudent surgeon would have stayed 2 millimeters away from Ms. Armstrong's ureter. This was a correct finding, and it was supported by expert evidence. Second, while there is a general principle or consensus in Canada that the standard of care should be determined prior to engaging in any discussion of causation, prior jurisprudence has established that there are certain instances, such as Ms. Armstrong's case, where causation can effectively inform the standard of care. Third, with regards to the evidentiary burden, the burden of proof should fall on the defendant in ruling out non-negligent causes. The reason for this, as my co-counsel will later explain, is because it is their professional background that actually renders them capable of eliminating other possibilities for medical errors. And ultimately, in terms of the issue of the standard of review, we argue that the majority at the Ontario Court of Appeal erred in applying a correctness standard of review. So beginning with the first issue on appeal, I will be addressing this with regards to what the requisite standard of care for medical negligence in Canada is, as well as how this is applicable to our specific case. So the appellant advances the following point. The trial judge did not err in his understanding of the standard of care in this particular case. So our objective here is to show the court why the trial judge was correct in concluding that a reasonably prudent surgeon would have stayed 2 millimeters away from Ms. Armstrong's ureter. So I would like to just take a moment to briefly return to the reasoning of both the trial judge as well as the appeal court. The trial judge determined that Dr. Ward did not take reasonable care and breached the standard of care that was expected of him by using the ligature within 2 millimeters of Ms. Armstrong's ureter. The Court of Appeal disputed this finding and found that the trial judge erred in his standard of care analysis. And the reason for this was because he inspected Dr. Ward's actions through a standard of perfection rather than a standard of reasonable care. So it was assumed that it was too high of a bar. More specifically, the court stated that ensuring not to bring the ligature within 2 millimeters of the ureter should not have been considered a step because it created a standard that was simply too high. This is incorrect, and I will explain why. In cases such as Critz versus Sylvester, the Supreme Court established that medical professionals in Canada must approach their tasks with a reasonable degree of care and knowledge. Similarly, in Terneuzen versus Korn, the court mentioned that a medical professional's work will be measured against the standard of a capable and prudent practitioner that is in the same field with similar experience. I should just note for you that specialists such as Dr. Ward are to be measured against the standard of practitioners within that specific field of practice. Taking these cases into consideration, we can see that at least in Canada, the standard of care that applies to Dr. Ward should be an inquiry how a reasonable practitioner in the same field with the same standing and experience would have addressed the procedure. As we know from expert trial, the witnesses unanimously agreed on the importance of identifying and protecting the ureter during a laparoscopic surgery. This was a point that was agreed on by Dr. Bernstein, Dr. Hagen, as well as Dr. Robinette. In other words, medical experts at the trial agreed on the point that not coming into contact with the ureter is a central aspect of this particular surgical process. The main point of disagreement, however, was with regards to how Ms. Armstrong's ureter was injured, as well as whether bringing the ligature tool within 2 millimeters of the ureter would have meant that Dr. Ward was breaching the standard of care. This was a point that was mainly disputed by himself. My co-counsel and I argue that their testimony affirmed the standard of care for a reasonable surgeon performing a laparoscopic colectomy, which is met by identifying and protecting the ureter and ensuring that the ligature stays a safe distance away from that area. I would like to emphasize this point by saying that the minimum standard of care was not only trying to avoid the ureter, but actually avoiding Ms. Armstrong's ureter. The second issue that I would like to bring the court's attention to is the following question. Does Canadian law regarding medical negligence permit causation to be used as circumstantial evidence to inform the standard of care? In responding to this issue, the appellant takes the position that the general principle in Canada is that the standard of care should be determined prior to engaging in any causation analysis. However, there are specific instances, such as the one before us, where the cause of the injury can effectively inform the standard of care. In these instances, it is necessary to first look at causation in order to be able to actually determine if the standard of care was breached. The trial judge held that Dr. Ward breached the standard of care expected of him as a reasonably prudent surgeon, and that it was specifically his negligence that resulted in Ms. Armstrong's ureter injury. The Ontario Court of Appeal disputed this and found that the trial judge's analysis was incorrect because it examined the cause of Ms. Armstrong's injuries prior to establishing the standard of care. This is incorrect, and allow me to explain why. So it is true that generally the standard of care should be identified prior to engaging in any discussion of causation. We saw this ruling in cases such as Bafaro versus Doe. The court affirmed that the standard of care and causation are two separate areas that require separate consideration and attention. However, despite these rulings, the court has allowed for certain instances that require a finding of injury prior to standard of care. It is important for me to note that in these particular moments, causation can actually be effective in informing the standard of care. As a point of reference, we see this come out in cases such as Kennedy versus Jacquiewicz, as well as Grass versus Women's College Hospital. Both of these cases are fundamental because they confirmed that there are exceptions to the general rule and that it can be, based on particular circumstances of the case, effective and necessary to examine causation in order to inform the standard of care.
Counsel, I'm not familiar with the cases you just cited. So in general, what kind of cases are we able to assess causation first? Is it more complex cases, more simple cases? When is that generally permissible?
Yes, of course. So I would respond to that by mentioning that I believe the main factor that would need to be taken into consideration is the complexity of the particular case. So for instance, in this case, one of the fundamental issues was that during the surgical process, the ureter was actually not in the view of the camera. And so due to that, the only way that causation can actually be inferred is through circumstantial evidence. So in order to actually be able to understand what happened during the specific process, because the camera was not showing the ureter, that is the only way that we can infer it in this specific case.
So counsel, are you saying that this is a more complex case? Because I'm not a doctor, so I'm not extremely familiar with this kind of surgery, but my understanding is this is a fairly routine surgery where there's routine things that can go wrong and routine side effects that can happen because of it.
Yes, so I would say that because the ureter was not in the view of the camera, that would make this case a little bit more complex. Also because at the trial level, there were expert witnesses who stated that there should have been a zero risk of injury to the ureter. And I believe that specific fact itself would make this a complex case compared to others.
Thank you, counsel. Thank you.
So with consideration to these rulings, Ms. Armstrong's case can be understood through a similar lens. For individuals such as Ms. Armstrong, causation can inform the standard of care expected of their respective doctor. The trial judge had considered two possible scenarios that were informing his understanding of the events that occurred. So he noted that either Dr. Ward used the ligature within 2 millimeters of Ms. Armstrong's ureter, or that he remained 5 to 15 centimeters away. This was a statement that was said by Dr. Ward himself at trial. We know that the ureter was not in the view of the camera during the surgery. This means that it was not visible how the injury occurred. For this specific reason, causation, so the injury and how it occurred, can only really be inferred through circumstantial evidence. This means that it becomes necessary for the trial judge to rely on circumstantial evidence, which would include the nature of the injury, in order to determine the standard of care. Thank you very much, Justices.
Good morning, Council. I believe this is where I take over. So on that note, I will dive right into the third topic that needs to be addressed with respect to the standard of care inquiry. We would like to note it is the plaintiff's role in ruling out non-negligent causes and providing supporting evidence. This is generally what we have understood to be the case in Canada, but I will proceed to explain reasoning as to why this is not necessarily always the case. As mentioned at the Ontario Court of Appeal, if a trial judge wishes to establish negligence as the sole cause of injury, then they must consider and dismiss all other non-negligent causes. With respect to the Court of Appeal's determination regarding the dismissal of non-negligent causes, my co-counsel and I would like to consider the final standard of care issue. Does the burden of proof regarding non-negligent causes in this case fall on Mrs. Armstrong? Upon this appeal, Ms. Armstrong submits the following argument regarding the law on the burden of proof and the plaintiff's role in ruling out the non-negligent causes of an injury. The burden of proof should fall on the defendant, given their professional background that renders them capable of eliminating other possibilities for medical errors. Presently, there is a body of law that supports the notion that some situations do allow for the defendant to rebut the presumption of negligence by providing evidence if it exists. In Snell versus Farrell, the court suggests that in situations that require a standard of care to be established or for the defendant to discharge their duty of care, it is the defendant's responsibility to provide evidence that rebuts the presumption. Specifically, Justice Sapinka asserts two principles in regards to the assignment of the legal burden of proof. Although the initial onus does fall on the plaintiff because they are the ones advancing the claim, if the topic of inquiry concerns specialized information that only one party is privy to, the onus may fall onto the party that is most knowledgeable under the circumstances. The ruling in Cooper versus Dr. Flood further supports this notion, as the court in this case established that once the only possible cause of the plaintiff's injury is determined to be from negligence, the evidentiary burden shifts to the defendant to challenge the finding. To provide some context, Cooper was a medical negligence case addressed at the Alberta Court of Appeal, where the defendant was a surgeon that was unable to provide non-negligent reasons for the plaintiff's injuries. When addressed by the court, the defendant did not provide evidence for other non-negligent causes, which ultimately left the court with negligence as the only plausible explanation. For good measure, I believe it's also worth noting the ruling in Austin v. Vibabuela, which reaffirmed that the burden of proof necessary to prove a breach in the standard of care falls onto the plaintiff unless the burden can be discharged with circumstantial evidence that results in an inference of negligence to be drawn. When this inference can be made, it becomes the defendant's responsibility to provide an explanation that rebuts the assumption. With respect to these rulings, we believe a similar course of action can be applied in the case of Mrs. Armstrong and Dr. Ward. It should be noted that thus far, Ms. Armstrong has presented evidence supported by reputable expert testimony that establishes her prima facie claim. And so in accordance with the case law presented, the burden must accordingly shift to Dr. Ward to present non-negligent causes for the injury in his defense. I also must note that although the case law bears weight in this situation, so does common sense and an understanding of medical capacity. Dr. Ward was the only individual present in the operating room while Ms. Armstrong was anesthetized. Any gaps in the narratives or potential explanations for the cause of our client's injury would best be explained by the medical professional who prescribed, moderated, and conducted the procedure. Given Dr. Ward's background, knowledge, and key role in the surgery, he is evidently the most suitable and capable witness to attest to the events that ensued. We believe that placing the burden of proof on the plaintiff's shoulders in a medical malpractice case confers an unreasonable standard for clients with likely a limited understanding of human anatomy and medicine. This really does raise a question of ethics as to how ordinary people, such as you and I, become responsible for playing detective and retracing the events that occurred before, during, and after the surgery. More often than not, individuals are incapacitated and not in a conscious or coherent state of mind to understand the details and reality of the situation and procedure.
Counsel, are you saying that it's always appropriate to reverse the burden? Don't we then run the risk of having a floodgate of medical negligence claims because there's such a low burden for plaintiffs to prove their claim?
No, I agree that it is not always the case, but I do believe that in exceptional circumstances where, pardon me if this sounds informal, but where surgeons kind of raise their hands and expert testimony suggests that there was no reason that such an incident would happen on an on a healthy colon, we believe in these situations that it should fall on the surgeon to fill in the gaps in the narrative. I'm not sure if that answered the question. Thank you.
Thank you,
Counsel, just to follow up on that question, was it not the case that there was some expert evidence presented by both sides in this case? And are we not requiring plaintiffs essentially to go and get an expert opinion that supports their position?
Yes, I agree. And we did have two different experts. I believe that it was Dr. Bernstein and Dr. Hagen that had the most powerful expert testimony. And Dr. Bernstein actually in our situation did agree that it seemingly was the ligature coming within 2 millimeters of the ureter. And while this is valuable information, expert testimony, it can really, it's uncontested in certain ways. But at the same time, there are variables where only Dr. Ward can really attest to the situation. Some details really are subjective. For example, if his arm was, these are just examples, but if his arm was accidentally knocked during the surgery, a shake in the room, these are variables that, science and objective evidence, expert testimony can only go so far. The remainder really does require a perspective from the defendant.
Thank you.
Thank you.
Counsel, I would like to follow up on your comments with respect to the non-negligent causes. Is it your position that the trial judge is obligated to consider the non-negligent causes?
Absolutely. I believe that in these situations that non-negligent causes should be considered for, just fairness sake. Doctors are doing a large task to society by undergoing these surgeries. And while we do understand there are implicit risks, we do give these doctors every opportunity to provide reasoning as to how this could have happened as a result of anything other than their fault or negligence.
Thank you.
Thank you. All right, from there, that perfectly wrapped up our third issue, and I will be able to delve into the final issue that we'd like to note, which is standard of review, where it must be considered whether the majority erred in their application of a correctness standard of review. My co-counsel and I respectfully disagree with the Court of Appeals application of a correctness standard of review. Based on our understanding of the facts, it seems as if the Court of Appeal usurped the power of the trial judge by disputing the findings of fact and evidentiary conclusions. As a rule of law, the drawing of evidentiary conclusions and determinations of fact are within the trial judge's jurisdiction. The appropriate standard of review would have encompassed the argument proposed by Justice Van Rensburg, who wrote the Court of Appeals dissenting opinion. In her statement, she affirmed the importance of paying deference to the trial judge on all findings other than questions of law. We believe that her assertion was valid as it acknowledged the determinations made by the trial judge were correct, available, and fully supported by expert evidence. With respect to the majority decision, it seems apparent the court did not award due deference to the trial judge and displayed preference for certain expert opinions over others. The appellant, Ms. Armstrong, requests two fundamental orders. First, that the court restores the findings and judgments of the trial judges, and second, that the costs are granted for her application. Ultimately, the evidence that my co-counsel and I have presented to the court today critically analyzes the four issues pertaining to standard of care and standard of review. Your Honor, we wish to conclude by affirming the magnitude of this case, not just on the life of Ms. Armstrong, who has lost her kidney, but on individuals who encounter medical practitioners and undergo life-altering surgeries. The reality remains that surgery is an integral part of our lives, and it is indefinitely a process that fuses trust, expertise, and professionalism. Moving forward, we must be mindful of the implications that may arise if analyses are too stringent or too rigid to allow for reality to seep through. Transparency within the medical field is essential, and I hope that moving forward, my client is able to move forward, knowing that her loss will never have to be anyone else's. Thank you.
The court now invites counsel for the respondent to begin.
Good morning, Justices. I'm Holly Pellatt, and my co-counsel today is Veronica Cesario, and we represent Dr. Ward. In our allotted time today, we will establish that the Court of Appeals decision should have been upheld by establishing four things. First, we will establish that the Court of Appeal applied the correct standard of care for medical negligence in Canada. Second, that while in rare cases, causation can be used as circumstantial evidence to inform the standard of care, it was unnecessary and inappropriate in the case at hand. Third, that the plaintiff has the duty to rule out non-negligent causes. And fourth, that the Court of Appeal applied the correct standard of review in this case. I will address these first two issues, and then my co-counsel will address the last two issues. With respect to the standard of care, we submit that the Court of Appeal applied the correct standard of care for medical negligence in Canada, which is that of the reasonably prudent physician. The correct standard of care was laid out by the court in Terneuzen and Corn and Sylvester and Kritz, and in these cases, the court held that the standard of care for medical negligence is that of the reasonably prudent physician. Additionally, the court has held that physicians, including surgeons, do not guarantee success and that they should not be held to a standard of perfection. The court has also established that a physician may make an error in judgment without committing negligence, so long as the error is not a result of carelessness, a lack of skill, or a lack of knowledge. And our friends have acknowledged this to be the correct standard of care in paragraphs 24 and 25 of their written submission. And we submit that they have failed to put forward any argument or supporting evidence which suggests that our client did not meet such a standard. Moreover, when assessing a reasonably prudent physician, what a reasonably prudent physician should have done in this case, the court must consider expert testimony in order to understand what is considered to be reasonable by medical professionals in the field. Specifically, in Hirschberg and Branson Drugstore, the court held that it was the court's role to listen to and apply experts' understanding of what is reasonable in a given case, because courts do not generally have the expertise necessary to make findings in the medical field without the benefit of such expert testimony. So in the case at hand, when we turn to experts to determine what a reasonably prudent physician would have done in Dr. Ward's circumstances, Dr. Hagen testified that he would try and stay away from the ureter. Therefore, in this case, we submit that the standard of care, as described by expert testimony, was that the physician must attempt to stay away from the ureter. We submit that Dr. Ward met such a standard of care because at paragraph 109 of the trial judge's reasons, the trial judge found that Dr. Ward, and this is a quote, took steps during the surgery to identify and protect the ureter. Therefore, as upheld by the Court of Appeal, we submit that Dr. Ward met the standard of care of a reasonably prudent physician as outlined by expert testimony. So ultimately, in order to uphold the current standard of medical malpractice law in Canada, in which surgeons are not held to an unattainable standard of perfection, but rather in which they must act as reasonably prudent physicians, Dr. Ward must not be held liable for negligence. To reverse the decision from the Court of Appeal would be to open the door to an attack on the entire healthcare system. It would be a slippery slope in which our legal system would not account for normal human errors. Secondly, we submit that while in rare cases, causation can be used as circumstantial evidence to inform the standard of care, it was unnecessary and inappropriate in the case at hand. So the court has held in Bufaro and Dodd, and again in Randall and Lakeridge Health Oshawa, that as a general rule, the standard of care and causation are mutually exclusive issues, and causation should not be considered until after the standard of care has been resolved. So specifically, the court has stated that the standard of care and causation are separate issues, and the issue of factual causation arises after the trier of fact has found that the defendant breached the standard of care. So while very rarely it may be acceptable to consider the nature of the injury as circumstantial evidence, when it is necessary to fully understand the course of events, this is not the issue at hand. Even to bring in circumstantial evidence would not answer the question of what actually happened in this case. As our friends mentioned, there are many different things that could have happened. There could have been a shake in the room, or there could have been a malfunction with the surgical tool itself. So in this case, the standard of care as correctly applied by the Court of Appeal is whether Dr. Ward acted like a prudent surgeon performing a laparoscopic colectomy. The nature of the injury is not relevant to whether Dr. Ward upheld the standard of care and conducted the operation in a manner that a prudent surgeon would have in the same circumstances. Therefore, we submit that while causation can, in some exceptional cases, be used as circumstantial evidence to inform the standard of care, it was not necessary or appropriate in the case at hand. And if there are no further, yes.
We heard that the ureter wasn't visible on the camera that Dr. Ward was using during the laparoscopic surgery. What was Dr. Ward's evidence as to how he protected the ureter or the steps that he took during the surgery?
We don't have specific evidence in that case, but his statement was accepted at trial that he identified and protected the ureter, and that was accepted by the trial judge as a statement of fact.
And counsel, could I just ask you, is this idea of, or this suggestion of not injuring the ureter, is that a step in the process or is that a goal of the process?
We're submitting that as a goal. That was the ideal outcome, and that Dr. Ward was attempting to get that ideal outcome, but that he is not held to a standard of perfection in which he must attain that goal.
And counsel, you said that only in exceptional cases should a causation be assessed first. What kind of exceptional cases are you referring to?
We're referring to cases in which doing so, in which an inference could only point to one outcome. In this case, circumstantial evidence wouldn't determine one outcome. Even if we look at the circumstantial evidence, there are various different things that could have happened to lead to the outcome that did.
Thank you.
So if there are no further questions, that concludes my submission for today, and I'll now turn it over to my co-counsel.
Good morning. My name is Veronica Cesario, and today I will complete the submissions on behalf of Dr. Ward. As my co-counsel indicated, I will discuss that the plaintiff has the duty to rule out non-negligent causes and that the Court of Appeal applied the correct standard of review in this case. First, I will counter three propositions proposed by the appellant to discuss why the plaintiff has a duty to rule out non-negligent causes. First, while the appellant submits the case of Cooper and Floor, which ruled that once the only possible cause of the plaintiff's injury is determined to be from negligence, the evidentiary burden shifts to the defendant to challenge the finding. This case is not relevant because Ms. Armstrong and Dr. Ward's case does not fall into these exceptional category of cases. The Court of Appeals stated that the plaintiff bears the burden to prove that negligence could have caused the injury in question, including ruling out non-negligent causes only in an exceptional category of cases. However, this case is not within this exceptional category. The trial judge found that in deploying a ligature within 2 millimeters of the ureter could cause damage by heat transmission, but not always does. In order for this case to be in the exceptional category where only negligence could cause the relevant injury, the trial judge would have had to find that there was no chance of accidental but non-negligent positioning of the tool. Second, the appellant submits that this notion by the Court of Appeal disregards the fact that Ms. Armstrong was not in a position of opportunity or coherence to understand the events that ensued throughout her surgery. Once again, this is a misrepresentation of what the Court of Appeals stated. The Court of Appeal did not create a new duty for plaintiffs, nor is there a duty for defendants to present non-negligent theories. The Court of Appeal held that if a plaintiff brings forward a theory that only negligence could have caused this injury, based on the injury alone, then the plaintiff would have the burden to rule out these non-negligent causes. The court did not require the consideration of facts outside of the trial. Third, the appellant submits that the burden of proof should fall on the defendant in ruling out non-negligent causes. However, it is not the defendant's responsibility to rule out these non-negligent causes. This concept closely resembled the expired legal doctrine res ipsa loquitur, what the court in Fontaine in British Columbia reaffirmed that the plaintiff bears the burden of proving on a balance of probabilities that negligence on the part of the defendant caused the plaintiff injuries. The invocation of this legal doctrine does not shift the burden of proof to the defendant. The correct interpretation of what the Court of Appeals stated and what occurred in Fontaine is that circumstantial evidence should be dealt with by the trier of fact by weighing the circumstantial evidence with any direct evidence to determine whether the plaintiff has established on a balance of probabilities a prima facie case of negligence against the defendant. Then the defendant can present evidence negating that of the plaintiff, or the plaintiff will succeed. As my co-counsel stated, there are exceptional cases where causation can be used as circumstantial evidence to inform the standard of care, but this is not the case here. In conclusion, the appellant misinterpreted the Court of Appeals ruling on non-negligent causes. The court did not create a new legal burden on the plaintiff to rule out these causes, and the court should adopt this court should adopt the Court of Appeals analysis of negligence. I will now proceed to discuss how the Court of Appeal applied the correct standard of review. The appellant submits that the Court of Appeal erred by being dismissive and not awarding the necessary deference to the trial judge's findings because they were dismissive of fact and law-based findings of the trial judge and his respective expert witnesses. We respectfully disagree. The Court of Appeal identified an error of law, not fact. The deference to trial judges is required for an error of fact. It is an error of law to incorrectly define the standard of care. The Court of Appeal applied the correct standard of review in this case. The Court of Appeal identified that the trial judge imposed an improper standard of care when measuring Dr. Ward's liability. The Court of Appeal found it was an error of law to use outcomes or goals as the standard of care, which the trial judge did. On a pure question of law, according to the leading authority, Hosseini and Nicholson, the appellate standard of review is that of correctness. The trial judge measured Dr. Ward's negligence by inquiring whether Dr. Ward succeeded in not coming within 2 millimeters of Miss Armstrong's ureter with the ligature, instead of asking whether Dr. Ward took the steps that a reasonably prudent surgeon would take. In finding that this standard of care was not correct, the Court of Appeal used the appropriate standard of correctness. In conclusion, we submit that we have established the following 4 points. First, that the Court of Appeal applied the correct standard of care for medical negligence in Canada. Second, that while in rare cases, causation can be used as circumstantial evidence to inform the standard of care, it was unnecessary and inappropriate in the case at hand. Third, that the plaintiff has the duty to rule out non-negligent causes. And finally, that the Court of Appeal applied the correct standard of review in this case. Therefore, we respectfully ask that this court dismiss this action against our client and uphold the Court of Appeal's decision. If there are no further questions,
There are.
Yes.
Counsel, can you tell me from your position, does what happened have any influence, or should it have any influence on the definition of the standard of care?
I believe that it should not in the initial definition of the standard of care. The standard of care should be that of a reasonably prudent surgeon and not what happened. And then the next step, the application of the standard of care, that is when we should take into account what happened and the actual facts of the situation.
And did the trial judge not find that the plaintiff had proved on a balance of probabilities that in fact the standard of care had not been met in this case?
Yes, they did, but we found that the trial judge incorrectly defined the standard of care by using coming into contact with the ureter rather than the steps that a reasonably prudent surgeon would take.
Right, and that's based on the suggestion that the not coming in contact with the ureter is a goal versus a step.
Correct.
Thank you.
Counsel, on the issue of ruling out non-negligent causes, if the plaintiff has presented evidence that suggesting that but-for causation has been met, would there not be would the defendant not have, excuse me, a burden of proving non-negligent causes as a defense to that but-for causation?
As a defense, but not as a requirement in the way that the appellant is submitting. In our opinion, we submit that there has been no change to the law of negligence in that the plaintiff puts forward their arguments and attempts to prove that the but-for step, and then the defendant responds as they would to defend their position. But if the plaintiff is bringing forward a theory that negligence alone caused this, negligence alone based on the injury alone caused this injury, then it's their responsibility to rule out the non-negligent causes. If there are no further questions, that concludes my submissions. Thank you.
The court now invites counsel for the appellant to begin their optional 3-minute rebuttal.
Your Honor, we feel comfortable with our submission and we do not need to speak further on this.
This concludes the matter of Armstrong v. Ward.